If you have a contested probate matter pending in court, it probably feels as though you're on track for trial. In reality, where you're headed to is actually mediation. The court, in almost all situations, will order you to appear in mediation in an attempt to resolve your case. If you have a disputed probate matter pending in court, you're likely aware of the fact that at some point you will be required to attend mediation. So what is mediation? Mediation is the process where both sides would appear before a neutral third party who in most instances is an attorney with experience in probate. And this process helps to facilitate a settlement outside of court. Mediation is usually very advantageous because of the fact that it's easier to get a mediation date as opposed to a court date. Mediation is also advantageous to the parties because it's not a win all or lose all situation, such as trial. You appear in front of a judge, you're subject to how this judge is feeling on this particular date, on whether or not your attorney is going to be able to properly present your case like it needs to be presented, or whether the judge is going to have other matters pending and shorten the presentation time by half. In those situations, you're going to be stuck with whatever the ruling is from the court, whether that ruling is good or bad. So mediation operates a lot differently. The neutral third party would gather both sides together, give his or her introduction on the process, have the parties agree that all the information and whatever is discussed during mediation is confidential. You'll sign that confidentiality agreement, and then the mediator will give the parties an opportunity to give a brief opening statement before separating everyone into different rooms. So the petitioner and his or her attorney would be in a room that's separate from the caveat or the opposing party and their attorney. The mediator will hop back and forth between the rooms in an effort to try to bring the parties close to a resolution. The mediator will not be concerned about the issues and the disputes and the hurt feelings. The mediator will solely be focused on a resolution. So he or she will get a good sense of what the issues are, what is it that the one party would be willing to accept and what one party would not be willing to accept. And during the course of this process, it may last 3 or 4 hours. The mediator will work to bring everyone together with a solution where you can walk out of mediation and feel fairly happy with. Mediation is not designed for one party to feel great and the other one feels lousy. It's like a divorce. Maybe neither party feels completely bad and neither feels completely happy, but you do have a resolution that you can live with. And most importantly, you have some input in that resolution. Unlike when you appear in front of a judge, you subject yourself solely to the ruling of the court. So does mediation work? It absolutely works, but mediation is going to be dependent on the participants. In some instances, there's just so much bad blood, there's so much history that it's almost impossible for parties to reach any type of agreement. Usually in that situation, the attorneys are aware of that fact and they'll petition the court or ask the court to remove the requirement that they attend mediation and just schedule the case for a hearing.